The law offices of Scoville and Scoville, serving the Sun Coast of Florida for over 35 years.
Hello, my name is Bart Scoville and I'm one of the attorneys here at Scoville and Scoville, and I'm here to talk to you about guardianship for adults. When a person is unable to manage their affairs or their person, then generally there is no alternative but to have a guardianship proceeding. Guardianship proceeding entails first an incapacity proceeding to determine how incapacitated that individual is. Once that is determined, a guardian is appointed. There are two types of guardianship. There's guardian of the person and guardian of the property. Guardian of the person makes personal decisions for the individual, and guardian of the property manages their assets. Generally this is the same person who is appointed, and not always is it necessary that both be appointed. The courts try to limit the intrusion as much as possible. However, even so, the proceeding is not terribly pleasant. It's necessary to have this individual's frailties brought up in an open court of law so that the judge knows how limited or broad to make the guardianship. So that's not terribly pleasant. In addition, from that day forward, the court will have supervisory role over the guardianship, and so there will have to be annual reports and accountings, and an attorney will have to be involved. So it can be a somewhat expensive process. Also, through a proper estate planning, it is, for the most part, avoidable with the use of a few different documents. First and foremost, you will need both a designation of healthcare surrogate and excuse me, and a power of attorney. What this does is the designation of healthcare surrogate allows that individual to identify who they want to make healthcare decisions for them in the event that they are unable, whether temporarily or permanently. The power of attorney also allows somebody to manage their assets for the same reasons. So between these two documents, they can avoid most guardianships. We also recommend a living will if you wish those types of issues to be addressed prior to the necessity of their use. And also a trust can sometimes be helpful in maintaining or avoiding a guardianship. There are a few instances where even these documents are not going to prevent guardianship, and that's if the individual becomes a danger to themselves or others. Of course, you'll have to have their rights removed. Or if a third party becomes involved, because with these documents the person's rights are not taken away. So if all of a sudden you've got somebody, housekeeper or something like that, is talking this individual into writing them substantial checks or transfer assets to them, then you're going to have to remove that individual's rights so they can no longer do that under the influence of this third party. So it's not a catch-all. There are instances when a guardianship will still be necessary, but the majority of the time these documents, and they're simple documents, will avoid guardianship and are definitely worth doing. So, thank you very much.
If you have any questions regarding the information contained in this program or any other legal issue, you can visit us on the web at www.scovilles.com or call us at area code 941-365-2252. Thank you.